Yes, I can hear you.
I would first like to say good afternoon to the interpreters, to the technical booth. Does everybody hear me? I can hear you. Thank you very much. I would also like to say good afternoon to the public who has come to watch these proceedings, as is required in an international public court. We are now in the preliminary proceedings, more specifically at the initial appearance of the accused, which is governed by Rule 62 of our Rules of Procedure and Evidence. Let me first turn to the Office of the Prosecutor. Ms. Hollis, would you please give us the appearances?
Good afternoon, Your Honors. Brenda Hollis, Michael Keegan, Kapila Waidyuratne appear on behalf of the prosecutor.
Merci. Thank you very much. Let me turn to the defense. Although we already know one another, Mr. Greaves, would you please introduce yourself and tell us what bar you are a member of and what your qualifications are for the tribunal? In any case, as you presented them to the registrar. Please proceed, Mr. Greaves.
May it please Your Honours, my name is Michael Greaves. I have for the last 23 years been a member of the Bar of England and Wales, in which I specialise in criminal proceedings. I have conducted 2 trials before this trial chamber, a number of initial appearances at the request of the registry, and I also have acted in other international tribunals. I hope that's sufficient for Your Honour's purposes.
Yes, absolutely, Mr. Greaves. This is only a formality because we already know one another and we are familiar with your qualifications. I will now turn to Mr. Prcać, who is appearing today for the first time further to an indictment which was drafted against him. Mr. Prcać, would you rise, please? And would you answer the questions that I'm going to ask you? Would you first please tell us your name and your first name?
Yes,
I apologize. I'm a little nervous, so if you accept, I would like to welcome you, Your Honor, to say good afternoon. I respect your tribunal. My first name is Dragoljub. My surname is Prcać.
Could you give us the date and the place of your birth, please?
I was born on the 18th of July, 1937, in a place called Omarska, the Prijedor municipality, in the Socialist Republic, that is to say in Bosnia-Herzegovina.
What is your profession, your residence? What were they before you arrived here?
I am a criminal technician, a retired one.
Are you married? And do you have any children?
I am married, yes, and I have 2 children.
For the time being, Mr. Prcać, I hope I'm pronouncing your name correctly. You may be seated now.
Thank you, Your Honor.
Today, this is your initial appearance before the tribunal. This is from a substantive formality in which you must be present and aware of what is being said along with your attorney, because it is only after your arrest when for the second time you were given the time, an opportunity to become familiar with all the charges that the Office of the Prosecutor has drafted against you, and that were confirmed by the confirming judge, waiting, of course, for evidence to be presented in intra-party proceedings. So that things will be clear, Mr. Prcać, I'm first going to ask the registrar to refer to the appropriate texts, which are those which give to you a certain number of rights and which will allow you then to move to the most important part of this formality of the initial appearance in order to ask you whether you wish to plead guilty or not guilty, and to know which counts of the indictment you are pleading guilty or perhaps not guilty to. I will ask you to be very attentive to the reading of the text, as well as to what your attorney will tell you, but I'm sure that your attorney is very familiar with the texts. Mr. Registrar, would you please read the text of Rules 20 of the statute and 62 of the rules, please? Yes. Article 20, opening and conduct of the trial. The trial chamber will ensure that the trial is fair and expeditious, and that the proceedings conform to the rules of procedure and evidence. The rights of the accused will be fully respected. Any person against whom an indictment has been confirmed, and in accordance with a warrant of arrest issued by the International Tribunal, shall after his arrest be informed of the counts against him and brought to the International Tribunal. The trial chamber will read out the indictment and be sure that the rights of the accused are accused, confirm that the accused has understood the rights, and then orders him to plead guilty or not guilty. The trial chamber will then set the date for the trial. The hearings are public unless the trial chamber has decided to hold closed sessions pursuant to its rules of procedure and evidence.
Article 21 du...
Rights of the accused, Article 21 of the statute. All persons shall be equal before the International Tribunal. In the determination of charges against him, the accused shall be entitled to a fair and public hearing, subject to Article 22 of the statute. The accused shall be presumed innocent until proved guilty, according to the provisions of the present statute. In the determination of any charge against the accused, pursuant to the present statute, the accused shall be entitled to the following minimal guarantees: in full equality, small a, to be informed promptly and in detail in a language which he understands of the nature and cause of the charge against him; to have adequate time and facilities for the preparation of his defense, and to communicate with counsel of his own choosing; to be tried without undue delay; to be tried in his presence and to defend himself in person or through legal assistance of his own choosing; to be informed, if he does not have legal assistance, of this right; and to have legal assistance assigned to him in any case where the interests of justice so require, and without payment to him by him in any case if he does not have sufficient means to pay for it; to examine or have examined the witnesses against him, and to obtain the attendance and examination of witnesses on his behalf under the same conditions as witnesses against him. Small f, to have the free assistance of an interpreter if he cannot understand or speak the language used in the International Tribunal. G, not to be compelled to testify against himself or to confess guilt.
Article
Rule 62 of the Rules of Procedure and Evidence. Initial appearance of the accused. Upon transfer of an accused to the seat of the tribunal, the President shall forthwith assign the case to a trial chamber. The accused shall be brought before that trial chamber without delay, and shall be formally charged. The trial chamber shall satisfy itself that the right of the accused to counsel is respected, read or have the indictment read to the accused in a language the accused speaks and understands, and satisfy itself that the accused understands the indictment. Inform the accused that within 30 days of the initial appearance, he or she will be called upon to enter a plea of guilty or not guilty on each count, but that, should the accused so request, he or she may immediately enter a plea of guilty or not guilty on one or more count. If the accused fails to enter a plea at the initial or any further appearance, enter a plea of not guilty on the accused's behalf. If the accused pleads not guilty, instruct the registrar to set a date for trial. In case of a plea of guilty, before the trial chamber, act in accordance with Rule 62 bis, or, before a judge, send the plea to a trial chamber so that it act in accordance with Rule 62 bis. Instruct the registrar to set such other dates as appropriate.
Merci, monsieur.
Thank you, Mr. Irad. Let me now turn to Mr. Greaves. Mr. Greaves, has the accused received a copy of the indictment in his own language? And has he understood its contents?
Well, yes, he received a copy of the indictment in the Serbian language at about 2:45 this afternoon. He had previously had conversations with another lawyer in which a discussion has taken place about the contents of the indictment, and I'm satisfied that for the purposes of today he's in a position to enter proper pleas that he has considered and decided upon. Can I add this, with a view to saving Mr. Abtahi's voice? I would respectfully suggest that we start at paragraph 13. I see little point in reading out for perhaps the fifth or sixth time the background to the Omarska case, with which I'm sure everybody is absolutely familiar. So if I might respectfully suggest paragraph 13 might be an appropriate place to start, and it will save some time.
Oui, merci.
Thank you, Mr. Greaves. I thank you very much for your suggestion, which will in fact facilitate matters. I will now turn to Mr. Prcać. Would you rise, please, Mr. Prcać?
Avez-vous bien...
Did you receive the indictment in your own language?
I received it today when I came here. I have a copy of the indictment in the Serbo-Croatian language.
Avez-vous...
Did you understand the contents of the indictment?
I have understood them. Yes, I shall read through them some more to get better acquainted with them.
Êtes-vous prêt?
Are you prepared today to tell us whether you plead guilty or not guilty to each of the counts?
Yes, I'm speaking.
Yes, I am ready.
Donc,
You may be seated, Mr. Prcać.
Thank you.
nous allons...
We will now, I'm going to say what I'm saying so that things be very clear. We will proceed in the following way. The registrar is going to read out the indictment, starting with paragraph 13, as suggested by Mr. Greaves. Remain seated while the indictment is being read. When we reach the counts, I will ask you to rise, and then I will ask you the question whether you plead guilty or not guilty. Have you understood what I said, and do you agree?
I have understood, and I do agree, yes.
Mr. Greaves, do you agree with this way of proceeding?
I'm perfectly content with the way Your Honour proposes to do it.
Thank you very much. All right, then, for the time being, I'm going to ask the registrar to read out the indictment, starting with paragraph 13. And when we reach the first count, he'll stop so that I can ask Mr. Prcać whether he pleads guilty or not guilty. Mr. Irad, you may now begin to read.
Je rappelle qu'il s'agit.
This is the indictment. The prosecutor against Dragoljub Prcać, case number IT 95-4I. General allegations, paragraph 13. Unless otherwise set forth below, all acts and omissions set forth in the counts of this indictment took place between 1 April 1992 and 30 August 1992. In each paragraph charging torture, the acts were committed by, or at the instigation of, or with the consent or acquiescence of an official or person acting in an official capacity, and for one or more of the following purposes: to obtain information or confession from the victim or the third person, to punish the victim for an act the victim or a third person committed or was suspected of having committed, to intimidate or coerce the victim, and or for any reason based upon discrimination of any kind. In each paragraph charging crimes against humanity, the alleged acts or omissions were part of a widespread or systematic attack directed against a civilian population, specifically the Bosnian Muslim and Bosnian Croat populations of the Prijedor municipality. Dragoljub Prcać is individually responsible for the crimes charged against him in this indictment pursuant to Article 7.1 of the statute of this tribunal. As defined by Article 7.1, individual criminal responsibility includes planning, instigating, ordering, committing, or otherwise aiding and abetting in the planning, preparation, or execution of any acts or omissions set forth below. The term participation, as used in the counts hereunder, is intended to incorporate any and all forms of individual criminal responsibility as set forth in Article 7.1. Dragoljub Prcać is also, or alternatively, criminally responsible for acts of his subordinates with respect to the crimes charged in the indictment by virtue of his position of superior authority in the camp, pursuant to Article 7.3 of the Statute of the Tribunal. As defined by Article 7.3, a person in a position of superior authority is responsible for the criminal acts of his subordinates if the superior knew or had reason to know that his subordinates were about to commit such acts or had done so, and the superior failed to take necessary and reasonable measures to prevent such acts or to punish the subordinates. Paragraphs 1 through 17 are re-alleged and incorporated into each of the charges described below. The accused. Dragoljub Prcać was born on the 18th of July 1937 in the village of Omarska, Prijedor municipality in Bosnia and Herzegovina. He served as a policeman in Croatia and then was a criminal technician for the Public Security Service in Prijedor municipality for several years prior to the conflict. He was the second deputy commander of the Omarska camp. In June 1992, he replaced Miroslav Kvočka as the deputy commander of the camp. As a deputy commander, he was in a position of authority superior to everyone in the camp other than the camp commander. Counts 1 to 3, persecution, inhumane acts, and outrages upon personal dignity. Between 24 May 1992 and 30 August 1992, Dragoljub Prcać participated in persecutions of Bosnian Muslims, Bosnian Croats, and other non-Serbs in the Prijedor area on political, racial, or religious grounds. The persecution included the following means: A. The murder of Bosnian Muslims, Bosnian Croats, and other non-Serbs in Prijedor municipality, including many of those detained in the Omarska, Karatim, and Ternopolje camps, amongst whom were the persons listed in the attached confidential schedules of additional particulars. B. The torture and beating of Bosnian Muslims, Bosnian Croats, and other non-Serbs in Prijedor municipality, including many of the people detained in the Omarska, Karatim, and Ternopolje camps, in addition to those listed in Schedule A. C. The sexual assault and rape of Bosnian Muslims, Bosnian Croats, and other non-Serbs in Prijedor municipality, including prisoners detained in the Omarska, Karatim, and Ternopolje camps, amongst whom were those persons listed in Schedule A. D. The harassment, humiliation, and psychological abuse of Bosnian Muslims, Bosnian Croats, and other non-Serbs in Prijedor municipality, including all the people detained in the Omarska, Karatim, and Ternopolje camps, as represented by those persons set forth in Schedule A. E. The confinement of Bosnian Muslims, Bosnian Croats, and other non-Serbs, including those persons set forth in Schedule A, in inhumane conditions in the Omarska, Karatim, and Ternopolje camps. Dragoljub Prcać instigated, committed, or otherwise aided and abetted the persecution of Bosnian Muslims, Bosnian Croats, and other non-Serbs in the Prijedor area on political, racial, or religious grounds, as well as the commission of the other crimes charged in this indictment through his direct participation in crimes and through his approval, encouragement, acquiescence, and assistance in the development and continuation of the conditions in the camp and the ongoing commission of crimes as described in paragraph 21 against the prisoners in the Omarska camp, including those set forth in Schedule A. As the deputy commander of the camp, Dragoljub Prcać had the authority to alter the conditions of confinement that existed in the camps. He had the authority to control the conduct of the guards in the camp and to prevent or control the conduct of any visitors to the camp. He had the authority to set the daily regime of the prisoners and to grant them more freedoms and rights within the camp, including access to potable water, reasonable living conditions and hygienic standards, and contact with their families or friends to receive clothing, hygienic supplies, food, and medicines. In addition, as a policeman on active duty, Dragoljub Prcać had an independent duty to uphold the laws in force on the territory of Bosnia and Herzegovina and to safeguard the lives and property of civilians. In addition, between 24 May 1992 and 30 August 1992, Dragoljub Prcać knew, or had reason to know, that persons subordinate to him in the Omarska camp were about to participate in the persecution of Bosnian Muslims, Bosnian Croats, and other non-Serbs in the Prijedor area, including those persons listed in Schedule A, on political, racial, or religious grounds, or had done so, and failed to take necessary and reasonable measures to prevent such acts or to punish the perpetrators. By his involvement in the above acts and omissions, Dragoljub Prcać committed. Now, stop for a moment, please, Mr. Registrar. Mr. Prcać, would you rise, please? Irad, would you continue to read out count one? Count one, persecution on political, racial, or religious grounds, a crime against humanity, punishable under Articles 5H and 7.1 of the Statute of the Tribunal. Mr. Prcać, do you plead guilty or do you plead not guilty to this count?
To this count, I plead not guilty.
Mr. Prcać, so that things be very clear, the question is whether you pleading. I'm not asking you whether you are guilty or whether you're not guilty. I'm simply asking you to plead guilty or not guilty.
Not guilty.
Okay. Very well. Irad, would you move to count two, please? Count two, inhumane acts, a crime against humanity, punishable under Articles 5I and 7.1 of the Statute of the Tribunal. Mr. Prcać, do you plead guilty or not guilty to count two?
Not guilty.
Count three, outrages upon personal dignity, a violation of the laws or customs of war, as recognized by Article 3.1c of the Geneva Conventions of 1949, punishable under Articles 3 and 7.1 of the Statute of the Tribunal. Mr. Prcać, do you plead guilty or not guilty to count three?
Not guilty.
For the time being, Mr. Prcać, you may be seated. Irad, would you continue to read, please? In addition, Dragoljub Prcać is criminally responsible for the crimes set forth in counts 1 to 3, pursuant to Article 7.3 of the Statute of the Tribunal. Counts 4 and 5, murder. Between 24 May 1992 and 30 August 1992, Dragoljub Prcać participated in the murder of prisoners at the Amarska camp, including those listed in Schedule A. During that period, camp guards and other Serbs allowed into the Amarska camp, who were subject to the authority and control of Dragoljub Prcać, murdered prisoners in the Amarska camp, subjected prisoners to torture and beatings that often resulted in death, and or confined prisoners in inhumane conditions which resulted in their physical debilitation or death. Dragoljub instigated, committed, or otherwise aided and abetted the murder of Bosnian Muslim and Bosnian Croat prisoners by his approval, encouragement, acquiescence, and assistance in those murders, including the acts described above and in Schedule A. In addition, between 24 May 1992 and 30 August 1992, Dragoljub Prcać knew or had reason to know that persons subordinate to him in the Amarska camp were about to participate in the murder of Bosnian Muslim, Bosnian Croat, and non-Serb prisoners in the Amarska camp, or had done so, and failed to take necessary and reasonable measures to prevent such acts or to punish the perpetrators. By his participation in the acts or omissions described in the above paragraphs, the accused Dragoljub Prcać committed. Mr. Prcać, would you rise, please? Irad? Count 4. Murder, a crime against humanity, punishable under Articles 5A, and 7.1 and 7.3 of the statute of the tribunal. Mr. Prcać, do you plead guilty or not guilty to count number 4 of the indictment?
Not guilty.
You read? Count 5, murder, a violation of the laws or customs of war, as recognized by Article 3.1a of the Geneva Conventions of 1949, and punishable under Articles 3 and 7.1 and 7.3 of the statute of the tribunal. Mr. Prcać, do you plead guilty or do you plead not guilty to count 5?
Not guilty.
For the moment, you may be seated, Mr. Prcać. And Mr. Ebrard, would you continue?
Thank you.
Counts 6 to 8, torture and cruel treatment. Between 24 May 1992 and 30 August 1992, Dragoljub Prcać participated in the torture and beating of Bosnian Muslim, Bosnian Croat, and other non-Serb prisoners in the Omarska camp, including those prisoners listed in Schedule A. During that time period, prisoners at the Omarska camp were subjected to torture and or severe beatings on a daily basis. For many prisoners, the beatings began upon their arrival at the camp and continued throughout their detention. Camp guards and others who came to the camp used all kinds of weapons and implements to inflict the torture and or beatings. Many prisoners were tortured and or beaten on repeated occasions. Dragoljub Prcać instigated, committed, or otherwise aided and abetted the torture and beating of Bosnian Muslim and Bosnian Croat prisoners. By his approval, encouragement, acquiescence, and assistance in the acts described above and in Schedule A. In addition, during the relevant time frame, Dragoljub Prcać knew or had reason to know that persons subordinate to him in the Omarska camp were about to participate in the torture and or beatings of Bosnian Muslim, Bosnian Croat, and other non-Serb prisoners in the Omarska camp, or had done so and failed to take necessary and reasonable measures to prevent such acts or to punish the perpetrators. By his participation in the acts or omissions described above, Dragoljub Prcać committed. Mr. Prcać, would you rise, please? Count 6. Torture, a crime against humanity, punishable under Articles 5F and 7.1 and 7.3 of the statute of the tribunal. Mr. Prcać, do you plead guilty or not guilty to count 6?
Not guilty.
Chef 7.
Count 7. Torture, a violation of the laws or customs of war, as recognized by Article 3.1a of the Geneva Conventions of 1949, punishable under Articles 3 and 7.1 and 7.3 of the statute of the tribunal. Mr. Prcać, do you plead guilty or do you plead not guilty to count 7 of the indictment?
Not guilty.
Chef 8.
Count 8. Cruel treatment, a violation of the laws or customs of war, as recognized by Article 3.1a of the Geneva Conventions of 1949, punishable under Articles 3 and 7.1 and 7.3 of the statute of the tribunal.
Prcać,
Mr. Prcać, do you plead guilty or do you plead not guilty to count 8?
Not guilty.
donc,
Mr. Prcać, you may be seated.
Thank you.
Mr. Ebrard, you may continue until the end. For the prosecutor, Carla Del Ponte, dated this 8th day of March 2000 at The Hague, the Netherlands.
bien,
Very well. We have taken note that Mr. Prcać has pleaded not guilty to all the counts in the indictment. Mr. Register, will you take note that Mr. Prcać has pleaded not guilty to all the counts in the indictment? Yes, Mr. President. Thank you very much. I would now like to turn to the Office of the Prosecutor. In respect of Rule 66A, have already made the proper, taken the proper provisions? Do you plan to make those provisions? Or what would you say to us about that, Ms. Hollis?
Your Honor, the prosecution has prepared copies of the supporting material that accompanied the original indictment, the supporting material that accompanied the amendment which resulted in indictment IT 98-30, along with a cover letter and receipt. Those are prepared and ready to be provided to Mr. Prcać. In addition, the prosecution also has copied the documentary evidence which has been provided to the accused in the case IT 98-30, and we are prepared to provide that. We have, in addition to that, prepared binders which have witness statements of all of the witnesses that are listed for the case IT 98-30. In addition to that, we have several witnesses who are relevant to this particular accused as well, and we have provided copies of those statements as well. We also have provided a copy of the list of agreed facts that the four accused in case IT 98-30 have agreed to, and we have that document available to provide to the accused.
Merci, Madame.
Thank you, Ms. Hollis. Mr. Greaves, do you confirm that you have received those documents referred to by Ms. Hollis?
Excuse me, Your Honor. We have the material here. We have not yet provided the material. The witness statements, because the receipt is very long, because there are many witness statements, the receipt and the witness statements will be available at approximately 6 o'clock this evening. The other material is here with us in the courtroom.
Excusez-moi, Madame.
Excuse me, Ms. Hollis. I'm afraid I didn't quite understand. I had understood, but you said it, so I apologize. Mr. Greaves, in any case, I have to give the floor to you now. Do you have any comments you wish to make? Any observations?
No, I was going to tell Your Honour that I hadn't received anything at all. I'm quite happy to take possession of such items as are available at the present time. It may take, if there is a long list, it may take some time to check before I sign my name to anything that in fact the documents correspond with the prepared receipt. But that's a matter that can be sorted out without any intervention from Your Honours.
Donc,
we have planned a status conference after this initial appearance. But I see that, Mr. Greaves, that you were assigned provisionally, and we would like to have the definitive counsel who's been assigned to Mr. Prcać in order to be able to work with the purpose as expressed of joining this case to the Kvočka case. We have taken several measures that if we have engaged the prosecutor so that he would be ready to submit the documents. They have done that. We congratulate them for them. But I think that it would be better to have a status conference with counsel who's going to be counsel to deal properly with those matters which must be dealt with and the matters that have to be dealt with. I therefore suggest that we have the status conference on the 22nd of March, which is the date given to me by somebody, and when I was told that we would by that time have in this courtroom the the definitive counsel, that we will not have our status conference immediately because we can do our preparatory work later, and therefore I suggest that you put aside the date of the 22nd, realizing that the time period for any preliminary motions must start to run as of today, once the prosecutor has prepared all the materials. Mr. Greaves, I see that you wish to say something, and I give you the floor.
I was just going to suggest that perhaps if you wanted to have a very brief status conference as such today, that might be of some assistance, particularly so that the defendant can know what the immediate program is, so that he can make proper preparations to consult with his advisors and so on. It may be useful, bearing in mind that he's only just arrived, for him to have some idea of what Your Honour has in mind in due course. Might I suggest that it would only take about 10 or 15 minutes at the most.
Oui, vous pouvez en faire.
Yes. Do you agree with that, Ms. Hollis? Agree to having a short status conference immediately after this hearing, so at least so that the accused will understand the way that we're going to work.
Your Honor.
Okay. Donc, merci beaucoup.
Thank you very much, Mr. Greaves. Thank you for your suggestion. We will adjourn for 20 minutes and then resume for a closed session. I'm saying this for the public gallery, so we're going to take a 20-minute break.
Veuillez vous lever.